this is the law that it's coming January 1st. But prosecutors and police are stepping up and saying, we're sounding the call here, folks, that witnesses, victims of crime could be in danger in cases where these defendants are just let right out. And in 90+% of the cases now moving forward, there will be no bail.
What does it take to get a more in-depth look into the week's top local news story? The Debrief brings you inside for a one-on-one conversation with our reporters. Every week, right here, right now. The Debrief.
Brought to you by Hackensack Meridian Health. Visit our partner site, NBCNewYork.com/healthyou, to help you on your health journey. Hackensack Meridian Health. Life years ahead.
From time to time, we like to do a kind of a 101, a workshop on big concept stories that you've seen in the news, some things that are going to happen that affect us all as a society. And this week, we're going to tackle criminal justice reform because in a few months, January 1st, 2020, there are some big changes that you might have heard about. But our Jonathan Dienst has been covering that, our senior investigative reporter, so he's going to kind of take us through it. Jonathan, I understand we're really talking about two waves here, and you recently did a piece on one wave, which is to say the discovery process, the pretrial evidence process that affects prosecutors, law enforcement, and victims and defendants. There's a separate component on bail for misdemeanors and nonviolent crimes that's being eliminated. But talk to us about what you highlighted recently on our newscast.
So all this is criminal justice reform, right? The right of defendants not to be locked up in jail awaiting trial pre-conviction. That's what this whole debate is about, and what's fair in terms of giving somebody bail or not. What we took a look at and what police and prosecutors are really concerned about is witnesses. You're going to have defendants arrested in drug cases. Perhaps they're gang cases where it's drugs. It's nonviolence, but it's still drugs. And a witness stepped forward and said, that's the guy who was selling drugs. Under the old format, the witness's name and identity was not revealed until much later, months and months later, just as the trial's about to begin. Now, under the new law, within 2 weeks, the name of that witness needs to be turned over to the defense and probably that drug suspect. The logic is the defendant has a right to know their accusers early on so they can make an assessment whether or not to plead guilty. What prosecutors and police are complaining about is saying that if you have a guy making bail who's a drug dealer and the witness who fingered him in the same building or on the same block or in the same neighborhood, and they're both out on the street together, that witness is going to be in danger. That witness is going to be afraid to cooperate. That witness is going to be afraid to tell their story. So there's a raging debate in terms of balance here. Where is the right of the accused versus what's being done to protect these witnesses? Already these DA offices and police departments are stretched in relocating witnesses to hotels and coming up with the budget. And all that takes time. And it's not just the witness who gets moved. Sometimes it's spouses. Sometimes it's children. Sometimes it's other relatives. It all depends on the nature of the offense and the crime that they were a witness to. But these are some of the complicating factors, and it's a debate that's been raging. Look, the legislature vote, this is the law that it's coming January 1st, but prosecutors and police are stepping up and saying, we're sounding the call here, folks, that witnesses, victims of crime could be in danger in cases where these defendants are just let right out. And in 90+% of the cases now moving forward, there will be no bail. And judges in New York under the bail reform law still are not able to take into account dangerousness as to whether to hold somebody behind bars or to set a bail amount. The only deciding factor is will they show up for court. And so that's the debate that's been going on, and it was an interesting take. We spoke with a witness who testified in Westchester against a drug gang. He's been moved several times to hotels. He's in fear of his life. But he says he was doing the right thing and he was trying to make his neighborhood better and safer by speaking up and pointing out who the bad guys were to help prosecutors put away some of the gang members. He says under this new law, he would have some real concerns, and a lot of people are going to be concerned.
So concerns about a chilling effect with witnesses and protecting them. Going back, as you pointed out, the Democratic-controlled Senate and Assembly now gets this through. This had been tried before, but Republican control in the Senate, I guess it would have been, it kind of held it up. So now you have this. Governor Cuomo buys in. They essentially agree with advocates who say that the system was weighted towards prosecutors and would ultimately kind of goad defendants into just taking a guilty plea because otherwise they were languishing and the prosecutors could hold back a lot of evidence. You pointed that out in your reporting, that argument.
Yeah, it's a very complicated debate. I mean, we spoke with State Senator Gianaris, who was one of the lead sponsors of these reform bills, and he said, look, how unfair is it? You arrest a guy, you lock him up in Rikers, you make him wait for trial, and if you plead guilty, in a lot of these guilty pleas, you can go home tomorrow if you just take the plea. Without knowing the evidence against you, without knowing who the witness is against you. So what are you going to do as a poor defendant who can't afford bail? Are you going to sit there for a year to fight your innocence, or are you going to take the plea to get out? They're saying it's an unfair choice and that they should be armed with the information early on. They should be able to make bail so that the process can move along and fair decisions can be made from the defendant's viewpoint. You know, I don't know if this person pointing the finger at me is telling the truth. You know, I said, well, you know, in our conversation with the state senator, I said, well, who's going to take a guilty plea if they didn't do it? And he says, well, if you're in that unfair situation and you don't have the resources, we have seen cases where people just take the plea just to get out versus sitting and waiting to prove their innocence, you know, months, if not a year plus later.
So there are some distinctions as to which crimes could be eligible for no bail, correct? But there are some gray areas that law enforcement are worried about, something that might be initially considered violent or a felony, but still could potentially put a suspect that might be a danger out on the street. That's their argument.
Right. I think it was John Miller in the police department recently were saying, look, unless it's murder, a murder, attempted murder, shootings, that's one thing. But there's a whole list of many, many other crimes now, drug dealing, where there's just going to be no bail. Right. And you're arrested, you're charged, and you're walking out right after your initial appearance without, you know, just with we'll see you in court at your next court date. And the point that they have is just because it's not a violent offense that time doesn't mean there isn't the threat or the implication of violence. Drug dealing, home invasion, burglary, you can name it. There's a whole list where you can say, I'm the witness or I'm the victim in that case, and now I'm on the same block as the person who I'm alleging committed a crime against me. It can lead to some dicey situations.
You pointed out in your story, Texas, which is known for rather rigorous law enforcement, usually, rather law and order type place. They did something similar and did not see the anticipated spike. Well, explain it.
There are 3 or 4 states now that have put these reforms in place. New Jersey is one of them as well. The difference in New Jersey, for example, is judges can consider dangerousness. So if somebody, has 15 past arrests and has committed certain assaults, the judge can take that into consideration when making bail determinations. And whether this person is a threat of doing the crime again if released on bail. New York does not allow for that. The public defenders we spoke with who said, look, even Texas is doing this, and they have not seen a considerable spike in assaults or retaliation on witnesses or defendants. I think the stat is maybe a 2% jump. I would need to go back and check that, but I think it's a 2% increase from before the law was passed and after, which is not a significant change, although if you take the list of horror, if you're the victim,
if you're in the 2%.
One is too many.
Yeah.
So again, it's a balancing act, and it seems the real objection from the law enforcement community is why, to this day, doesn't New York allow for dangerousness to be considered when setting bail? What are the chances that this person is going to go out and commit the crime again, and a judge sitting in that chair have the authority and the discretion to make that call? The defense lawyers will say it's terribly unfair. It's sometimes racially biased, if you look at the stats, that it's an unfair system if you allow that type of judgment to be made in trying to predict future crime. So that is the defense side saying it's a really unfair standard, and better that we let 100 guilty people go free than we lock up that one innocent person, is the philosophy and mindset
And also
behind these discussions.
Trying to address poverty or wealth and inequality in terms of being available to access the system.
Yeah, you can look at the number of cases where the same crime, the guy with money gets out because he can afford to, the person who's poor
is just languishing. As the city wrestles with what to do about Rikers, or what to do in the foul aftermath of Rikers. Real interesting reporting, Jonathan. I would encourage anyone to go link to it at NBCNewYork.com, because we are probably going to be talking more about it as we approach the January 1st deadline. Mr. Dienst, as always,
David,
good to see you.
Thanks for having me.
Good to see you on YouTube, I think, too.
That's right.
There. We want to thank our producers, Jesse Edwards and Ben Berkowitz from the NBC New York digital team, as we come to you from our busy newsroom. And we'll check with you next time on The Debrief.